Okay, so same day, August 25th, 2022. Now, what I'm going to do now is I've got this first video uploading, right? And I am going to read this with just read. I'm not going to make comment on. I will do that on the next video, okay? I just want to read through this as is, and then I'm going to post it, basically. I may say something after, at the end, when I'm done reading it, just as a summary, okay? And then I'm going to post it, and then we're going to backtrack, probably not today, but at a future date, and nitpick what he wrote, basically. This is Judge Ross, okay? And so, you know, just bear with me, okay? And then I think before I go to the hospital, which I was going to try and do next week, I think I should just go downtown to the courthouse and just put an appeal in with 1 page. Yep. The government is being negligent by protecting criminal activity. Something simple. Real simple. Pay my $200. Government will come right up behind me with their form to dismiss it, with their same case law, with their binders, okay, of everything that I submitted, and top of whatever. They just send in the same stuff over and over and over again. They don't acknowledge it. They ignore it. They expect me to draw lines through it, and when it's staring them in the face, they still ignore it, right? They're negligent people, okay? And then I'll just deal with it. And then, of course, I'll be in front of 3 judges, assuming I'm not in jail by then, or who knows what will happen to me and my family. Who knows, people? Seriously. Okay? But I'll cross that bridge when I get to it. So I think that's what I'm going to probably end up doing. I'm just letting you know that I'll probably, before I go to the hospital, I will go downtown and I will file an appeal with 1 page, stating that the government enables criminal activity, they endorse it, and they protect it. And they are wanting it to happen. Because they know nothing can stop them from allowing it to happen. Right? They want it to happen, people. Old people represent too much money, right along with young people's bodies and their body parts. Just way too much money. They don't want to rock no boats. They got their system finally greased, and they want it to keep going and going and going and going and going and going like an ever-ready battery. Okay, so what we're going to do is we're just going to read this. Andre, you have to turn it down. I got 17 pages to read. Okay. Or 16 or whatever's here. And I'm just going to read. It's so dark. I can't see. That's not big enough. I don't want to hear it. Okay? Seriously, I do not want to hear it. Is that good? Yeah. Because, no, even more. Because it's hard for me to focus with my eyes.
Is that better?
Just keep it low, okay? Thank you. All right. The defendant, Her Majesty, and the Queen in Right of British Columbia, the Crown, applies for an order striking out the notice of civil claim and dismissing the plaintiff's action. The Crown's arguments are based on several grounds which I discuss below. 2. In response, the plaintiff's position is that her claim is properly based on the mistreatment that she and her family have received from various government agencies and their employees since 1990. I note that the plaintiff is self-representative in this action. She was ably assisted by a friend at this hearing. Could be AI for all we know, people. Be prepared for AI. 4. I also wish to stress that I have significant sympathy for the plaintiff. As I discussed below, she has lost 2 daughters. She is the primary caregiver for her disabled grandson, among others. She is a resilient person who has dealt with many setbacks over the years. 5. Despite my sympathy for the plaintiff, it is clear that her claim must be dismissed. Issues and findings, okay? 6. The issues for me to decide in this application are whether the province has established A, that the plaintiff's action is bound to fail. B, that the plaintiff's allegations are frivolous, vexatious, or scandalous. Or C, that the plaintiff's notice of civil claim is an abuse of process. 7. For the reasons set out below, I grant the defendant's application. I strike the notice of civil claim and I dismiss the action. I do not grant liberty to amend. I find that the action is A, bound to fail because the plaintiff has no standing, and B, is an abuse of process because it represents a collateral attack on a prior decision of this court. 8. Having made those 2 findings, I do not need to consider whether the action is frivolous or vexatious. The notice of civil claim. 9. In order to understand the notice of civil claim, certain tragic events in the life of the plaintiff and her family must be understood. Briefly subscribed, the main events are as follow. A. For more than 2 decades, the plaintiff and her family lived with a man named John Duncan. She says that he was like an uncle or surrogate grandfather to her children. In addition, the plaintiff held his power of attorney. I understand that Mr. Duncan was removed from the Chorney family home by Mr. Duncan's sister, who relied upon different power of attorney to take control of his person and his finances. Mr. Duncan was hospitalized at a facility within the Fraser Health Authority. I can't make comment right now. B. 2 of the plaintiff's daughters, Shamay Chorney and Sierra Chorney, have died. I understand that both deaths were ruled to be accidental drug overdose. I will make comment on that. There was no mention of this when we were discussing whatever we were discussing. This man assumed this information on his own. Okay? The plaintiff does not accept those findings. She also believes that the two women's remains were abused after their deaths. The plaintiff's grandson, Amari D. Johnson, was born to the plaintiff's daughter, Shamay Chorney. Amari has suffered from a severe disability since birth. Can you be quiet?
Yeah.
Since Shamay's death, the plaintiff is now his primary caregiver. She alleges that there was negligence and cover-ups in relation to the care that Shamay received before and during his birth. In addition, the plaintiff has had several disputes with different ministries of the provincial government over the past quarter century, including the apprehension of her son, Andre Chorney. Andre is not my son. Andre is my grandson. Andre is the son to Sierra Chorney. Must be a typo, right? 10. Elements of these events are included in the Notice of Civil Claim. 11. The statement of facts in the Notice of Civil Claim is 153 paragraphs long. It is convoluted. It is not capable of a response. By that I mean that it would be difficult or impossible for the defendant to properly understand all of the allegations and properly respond to them. 12. In the section of the Notice of Civil Claim that sets out the relief sought by the plaintiff, Ms. Chorney described the following remedies that she is seeking. 154. Assigning the name of Chorney to be listed on the birth certificate of Amari D. Johnson. 155. Correct all or any medical files relating to Amari D. Johnson and Shamay Chorney that have been falsified and or altered to be misleading with misinformation. 156. Order a proper and full investigation into the murder Shamay Geraldine Chorney and the cover-up of her murder so that illegal organ harvesting could occur without notice being paid to those who facilitate such gross and indecent illegal activities in the province of British Columbia, Canada. 157. Grant letter of administration to Judy Chorney over the affairs of Shamay Chorney. Paragraph 158 and 159 of the Notice of Civil Claim reference two other BC Supreme Court actions, and then of course that's Fraser Health Authority, CIBC Bank. I will return to discuss those two actions below. Number 14. As noted above, the foundation of the notice of civil claim is mistreatment of the plaintiff and her family by various government agencies and their employees since the 1990s. The claims fall into several general categories relating to specific individuals. Mr. John Duncan, 15. I am informed that Mr. Duncan passed away in 2017. No, he passed away in 2018, in January. January of 2018, Shamay was murdered in 2018, in April. 16. The notice of civil claim alleges that for a period of 23 years, until 2015, Mr. Duncan lived with the plaintiff and her family. The plaintiff held Mr. Duncan's enduring power of attorney. "17. The plaintiff alleges that Mr. Duncan's sister, in combination with the Canadian Imperial Bank of Commerce, CIBC, and Fraser Health Authority, improperly removed the plaintiff as Mr. Duncan's attorney. The plaintiff alleges that at the same time, Mr. Duncan's sister removed Mr. Duncan from the plaintiff's home. No, she removed him from a care facility in a hammock, drugged up. And then when she got across the water, she rushed across to the emergency room there and said that's how they found him in Vancouver, from a care facility that they took him out of, that he'd been in Fraser Health Authority for 40 days. I know I'm not supposed to say anything, but of course the judge is ignoring all that, right? Plaintiff's home. They didn't take him from my home, people. From the plaintiff's home, and then prevented the Chorney family from visiting with him through to the time of his death. She says that all of the steps were taken against Mr. Duncan's wishes. She wants the circumstances of her power of attorney and his removal from her home to be investigated. He wasn't removed from the home. He was detained illegally in a care facility and wasn't released, as they were committing bank fraud and mail fraud and other fraud to seal the deal with stealing his money. Anyway, I'm not supposed to say anything, right? Sierra Chorney. Sierra Chorney was the plaintiff's daughter. She died in March 2020 of an apparent overdose. 19. The notice of civil claim alleges that the plaintiff was not allowed to identify the body of her daughter for 19 days after her death. She also alleges that she has not received the results of any investigation into her daughter's death. She alleges that there has been misconduct by employees of Fraser Health Authority. She further alleges that Sierra's organs were illegally harvested and sold on the black market. The plaintiff says that these acts constitute evidence of a pattern of public sector employees targeting vulnerable families like hers for nefarious purposes. Those purposes include illegal organ harvesting. Andre Chorney, number 20. Andre Chorney is the plaintiff's son. He's my grandson. He's not my son. Must be a typo. She alleges that he was apprehended improperly by the Ministry of Children and Family Development. She was forced to refrain retain counsel and obtain a provincial court order returning Andre to her care. She points to this episode as another example of members of the public union sector targeting her because she is a vulnerable person. Number 21. Andre was returned to her care in 2014. What happened to Sierra? Shamay Chorney, number 22. Another of the plaintiff's daughters, Shamay Chorney, was pronounced dead on April 11th of 2018. Well, right there, people, I'm sorry. That's not what the paramedics said. That's not what Fraser Health Authority staff said. That's not what Dr. Barr said, right? I mean, let's face it. They loaded her up in a hammock, took her to the hospital, put her on a bed, and kept her there for 9 days as her body decomposed. But for whatever reason, the judge seems to think that she was pronounced dead in the basement. Okay? These are his words, not mine, people. I'm going to put this in PDF form, and I'm going to put it into my, my description box in the next couple of days in terms of, what is that called? Google Documents. Okay, so anyway, he's under the impression that they pronounced her dead. Okay? That's not what they did. They didn't pronounce her dead. The excuse was that she wasn't dead, and that's why they took her to the hospital. Otherwise, if they would have pronounced her dead, they would have had to do an investigation and call the coroner in. And being that the circumstances were the way they were, they would have had to do a forensic autopsy with 2 cops witnessing it right away. They didn't want that to happen, okay? They wanted her organs, so they bypassed that. That's why they took her to the hospital and did what they did to her in the hospital. Okay, so carry on. Shamay had been, let's start from the beginning. Number 22. Another of the plaintiff's daughters, Shamay Chorney, was pronounced dead on April 11th of 2018. Shamay had been in hospital for 9 days before she was pronounced dead. Are you listening? Huh? Quiet. Another of her plaintiff's daughters, Shamay Chorney, was pronounced dead on April 11th, 2018. Shamay had been in the hospital for 9 days before she was pronounced dead. It is not disputed that Shamay died of a drug overdose. However, he's assuming, people. However, Shamay was murdered, people. I put down murder, people. However, the plaintiff alleges that her daughter was murdered. So who is he disputing with in terms of, he's just, right? It is not disputed that Shamay died of an overdose. Who is he disputing with? He's not disputing it. I'm saying she was murdered, but he's saying no, she wasn't. Just like with that paramedic who came to my house. Amari is the way he is because the mother was doing drugs. No, that's not true, right? And then what did he do? He didn't like the answer, and he turned around and he sicked MCFD on me, okay? As the government is trying to throw out this shit by twisting words around. I know I'm not supposed to say anything, but this upsets me, people, because you could write it to the best of your ability, call in those legislations, call in the criminal code. You can cite this, you can cite that, you can write it out from detail to detail, and they just bypass it. Okay, Shamay died of a drug overdose. Okay, it is not disputed that Shamay died of a drug overdose. However, the plaintiff alleges that her daughter was murdered. For that reason, and for the reasons set out below, she seeks an order of this court requiring a full investigation. Number 23. Further, the plaintiff alleges that the RCMP and the Fraser Health Authority provided false information about the circumstances of Shamay's death. Included in that allegations is the plaintiff's belief that her daughter actually died before she was admitted to hospital. The plaintiff alleges that the hospital then placed the dead body in a hospital bed for 9 days while the body deteriorated and decomposed. The plaintiff alleges that she could tell that her daughter had been embalmed on the first day she was in hospital. I understand that Shamay Chorney was pronounced dead after certain life support machines were unplugged. 24. The plaintiff also says that the family's wishes regarding visitation to her daughter's hospital room were ignored. I understand that the family did not want Shamay's boyfriend. He was not a boyfriend. He was an ex-boyfriend. Okay? The judge is being misleading more than once in this. Okay? The family did not want Shamay's boyfriend to be permitted to visit her. She also alleges that her daughter's organs were illegally harvested by syndicate of criminals. The plaintiff links that allegations to the province by saying that the province uses hospitals to illegally harvest organs, using its employees to carry out heinous crimes, participate in witchcraft and sadism, target the Chorney family, and endorse gang stalking behavior against them. 25. The plaintiff alleges that there has been no proper police investigation into her daughter's death. In addition, she says that the medical records have been falsified to indicate that the plaintiff, as Shamay's mother, refused to donate Shamay's organs. The plaintiff seeks an investigation into these allegations as well as access to Shamay's medical records. I have Shamay's medical records, people. I don't have Sierra's, though. That's the big fish. They don't want me to have Sierra's. 27. Amari is the plaintiff's grandson, the son of Shamay Chorney. 28. I am informed that Amari was born with cerebral palsy. The plaintiff complains about the medical care that Shamay received leading up to and at the time of his birth. I understand that he was born at a hospital within the Fraser Health Authority. The plaintiff says that the hospital records relating to his birth have been edited. I don't know. I don't remember saying that, but this is the other element of correction of hospital well, except for where they took his blood count from when he was born and then inserted it into when they botched that MRI and they wanted to spread that rumor of him having drugs in his system. Okay, I'm pretty sure it's copy and paste. So that must be what we're talking about here. Okay. We're up here. Okay. And at the time of his birth, I understand that he was born at a hospital within the Fraser Health Authority. The plaintiff says that the hospital records relating to his birth have been edited. This is the other element of correction of hospital records that the plaintiff seeks in the notice of civil claim. Other claims. In addition to the events in the categories listed above, the plaintiff makes other allegations in the notice of civil claim spanning the period from the 1990s through to the present time. Those allegations include the removal of the Chorney family from social assistance and other public programs beginning in 1990s. She says that this series of events discloses a pattern of conduct by public sector union employees against her and her family. Position of the defendant. Number 30. The defendant argument is multifaceted in order to address the variety of claims made in the notice of civil claim. John Duncan. As part of the evidence on this application, defense counsel tendered pleadings and prior decisions of this court in other actions commenced by Ms. Chorney. Those actions have an influence on my decision. 32. Actions number, okay, the plaintiff sued the Fraser Health Authority. Now, you have to remember, people, I wasn't allowed to submit any documents. Right? They had me amending and then just proceeded to throw it out. They never asked for documents, nothing. Only Judge Ross got those 370 pages of legitimate documents, but he's ignoring them all, basically based on the 3 judges prior that were ordered by the government to throw it out based on one form to dismiss it. Okay. So he's basing his decision on throwing out Uncle John based on 3 other judges that never looked at any evidence, even though Judge Ross had evidence in front of him. But because those other judges threw it out, somehow it made it okay for him to throw it out, because the government told him to. Okay. And okay, so 2 actions referred to, let's go, okay. In action number S171469, the plaintiff sued the Fraser Health Authority. I note that this is one of the 2 actions referenced in the plaintiff's notice of civil claim. See paragraph 14 above. That action related to John Duncan and the power of attorney. Enduring power of attorney, just all of it. It's beyond the power of attorney, but besides that point, he went in for a flu, people. He lost his life over it. Number 33. In the notice of civil claim, in action number S171469, the plaintiff alleged that the Fraser Health Authority provided negligent medical treatment to Mr. Duncan and further that the negligent treatment led Mr. Duncan to being removed from the plaintiff's home and care. Well, he wasn't in my care, people, because he didn't need care. He was looking after the house and Andre when I slept for a week, and then he got the flu, okay? He was fully functional until he got that flu, people, until he showed up at the Fraser Health Authority hospital, people. He looked after Andre for a week while I slept, people. Does that sound like a man who needed care? The way this guy's trying to make him sound like? Further, the actions of the health authority allowed Mr. Duncan's sister to take over as his attorney. Okay? Further, the actions of the health authority allowed Mr. Duncan's sister to take over his attorney under a new power of attorney. They did that on the 20th, the day after I left Uncle John on February 19th. He told me to go get a lawyer to stop whatever it was that these individuals were trying to do to him. And Eleanor came in the next day and cut a deal with the Fraser Health Authority staff on the 20th. And the judge is condoning it. But I have Uncle John telling me to go get Paul the lawyer, to which the judge would have seen that video. And he's completely ignoring it, people. And they had him in the hospital system for at least 40 days. But they needed to transfer his mail in order to find out where his bank was before they could seal the deal with the bank. So clearly the judge didn't look at anything that I gave him. So maybe I should photocopy it all, put it into freaking PDF file, and post it on fucking line. And make it public. Yeah. Maybe. Like, this is pathetic. So let's read that again. This is pathetic. Further, and like, how would this judge know this? How would he know this? Where did he get this information from? Further, because this is to me like new information. This just confirms. Okay? Further, the actions of the healthcare authority allowed Mr. Duncan's sister to take over as his attorney under a new power of attorney. The plaintiff further alleges in that action that she had not seen Mr. Duncan since 2015. Within, this is number 34, within the prior action, S171469, the defendant, through an application to strike the pleading and dismiss the plaintiff's claim, the defendant's application was granted by Justice Bowden on December 7th of 2017. Justice Bowden found at paragraph 8 that it is plain and obvious that the claim that I could discern from the notice of civil claim would fail, even if the allegation, even if the alleged facts are assumed to be true. So even if they're assumed to be true, they're bound to fail because Judge Bowden said so. "35. I note that Justice Bowden stated in his oral reasons at paragraph 5, she did not provide the court with a copy of a power of attorney." That's not true. I handed over what I had, people. Only I had to do it from standing, you know, where the lawyers stand. I never submitted it through the court registry, right? I just came in with it. And then, this is when they were trying to throw it out, right? This is after the amendment, okay? And, you know, he was, and I said, well, no, I have. He goes, oh, you got it now? I said, yeah. And I showed him, people. Okay, now, I'm pretty sure I had the enduring power of attorney at that time because this was in December of 2017, and I got that enduring power of attorney in 2016. I have it time-stamped. Okay, so they're fucking lying. They're fucking lying. They're jacking each other off, okay? They're jerking each other off here. This is what it is, people. I don't care. Okay? She did not provide... That's not true. I handed it over, and he sat up, and then they... Through the clerk, right? Whatever, the you know, the people who do that. I handed it over. He looked at it, and he said, yeah, well, maybe you do, maybe you don't. Get out of here. Even though it was in black and white. I didn't file it with the court registry, people, because I wasn't ready to hand in all my documents because I was still working on shit. That's why it needed to be going to trial, so I had the chance to put everything together so that, right? Okay, this makes me so ill, you don't know. She did not provide, he's lying. this Judge Bowden is lying. She did not provide the court with a copy of a power of attorney, as it was a power of attorney that related only to financial matters. It would not give her standing to proceed in court against Fraser Health Authority on his behalf. So they're completely removing the enduring power of attorney, and they're just trying to bring me down to convince me through that metaverse where you got looking straight ahead with the headphones on, nothing around you, and you get brainwashed to believe the lie. They keep feeding me their lie, hoping that I will accept their lie, people, when I have the paperwork, as they choose to ignore the legitimate paperwork. Because it's their lie. It's not my lie, it's their lie. And they're hoping that I'll just accept their lie, and I won't. In this action, the plaintiff argues that this paragraph contains a factual error. She says that she had an enduring power of attorney, hence my understanding is that she brings this action against the Crown to have that factual matter cleared up, and thus have her claim heard. The defendant says that this is an obvious, improper, collateral attack on Justice Bowden. Now they're accusing me of attacking a judge who failed to do his job, which is a breach of trust under the Criminal Code of Canada, to which these judges shit on. Collateral attack on Justice Bowden's decision, and thus is an abuse of process. I discussed that submission below. 37. Continuing on with the narrative, after the plaintiff's action against Fraser Health Authority was dismissed by Justice Bowden, Ms. Chorney sought to appeal that decision. She applied to the Court of Appeal for a no-fee order on February 28th of 2018. Justice Savage dismissed the plaintiff's no-fee application on the basis that her appeal had no merit and was bound to fail. He wrote at paragraph 1011. Remember, I was told I was going in to do nothing more than waiver my fees so that I could go in front of a 3-panel judge under a different form. Form 1, fill this out. You can write 3 pages to waiver your fees, and once your fees are waived, being that you don't want to pay the $200, then you fill out this form to appeal. I did both, but before I could get a date for the appeal, I had to waive my fees. So that's how I ended up there first. And I was told I was only allowed 3 pages. Andrew came in with his binders like this. And they turned it into a mini trial. And then the judge sicked the sheriff after me. And then he told me to take it to the cops. He never said that he dismissed it. He said just take it to the cops. And then Shamay was murdered. Soon after that. How convenient. 37. Continuing on with the narrative, after the plaintiff's action against Fraser Health Authority was dismissed by Justice Bowden, Ms. Chorney sought to appeal that decision. She applied to the Court of Appeals for a no-fee order. On February 28th of 2018, Justice Savage dismissed the plaintiff's no-fee application on the basis that her appeal had no merit and was bound to fail. He wrote at paragraph 1011. Okay, this is what he wrote. In my view, it's an opinion. I'm supposed to come in with material facts and nothing more and nothing less. But these guys can just import their opinions and their biases and their prejudices. Okay. And their racist attitudes. Okay. And self-interests. Okay. In my view, this appeal is one that is bound to fail, as Ms. Chorney's pleadings disclose no perspective of success. Ms. Chorney lacks standing to bring an action for alleged harm done to Mr. Duncan, whether he is alive or dead, which on the pleading is not clear. If he were alive, and if she only had a power of attorney, that would not be sufficient. See, what happened to the enduring power of attorney? Why are they ignoring it? Time after time, judge after judge, acting like it didn't exist, people. They're trying to jimmy their little papers to hide it, that it was there for 25 years, okay? This Judge Ross has a copy of it. I passed it over to the judge when he asked me, okay? And they ignored it. Okay. If he were alive and she only had a power of attorney, that would not be sufficient to support these claims. If he was deceased, the action would have to be commenced by or on behalf of his estate. If he was incapacitated, she would have to be appointed his guardian ad litem. In the hearing today, Ms. Chorney advised that Mr. Duncan is in fact deceased. Because they're not acknowledging the enduring power of attorney, people. They're burying it. They're burying it from judge to judge, from court case to court, like from court date to court date. And then when it's staring them in the face, they're still ignoring it, acting like it doesn't exist. And I don't know how people can't see that these guys are all sitting around in a circle just jacking off. Okay? Like, like some boys club, to see who can piss the farthest, right? And think it's funny. 11. If, on the other hand, Ms. Chorney brings an action on the basis of harms done to her, the law is clear that the Fraser Health Authority must owe her a duty of care, and she must allege facts demonstrating that they have breached that duty of care. The pleadings are prior, but that said, the facts alleged in the pleadings do not persuade me that the judge erred in findings that the claim disclosed no reasonable prospect of success, as it is not alleged that Fraser Health Authority owed her a duty of care and breached that duty. No, they owed Uncle John a sense of duty of care to which they breached time after time after time after time, and they're continuing to breach it because there is no duty of care. Okay, we can see that with Amari. We've seen that with Sierra. We've seen that with Shamay, right? We can see that with me. "38. Justice Savage further noted that to the extent the plaintiff complains of criminal activity, the proper remedy is a complaint to the police. You don't ask the fox to investigate itself. The police are involved in all this stuff, people. Okay? However, the appeal to that dismissal is still technically extant. 40. The second action commenced by the plaintiff S171468 names CIBC as the defendant in that action. The plaintiff claims that the bank improperly removed her as the attorney. Not talking about enduring power of attorney now, is he? Or power of attorney. He's just saying attorney, right? The attorney for Mr. Duncan. As noted, Mr. Duncan's sister took over as his attorney pursuant to a new power of attorney. The day after Uncle John told me to get a lawyer, to which that judge basically ignored Uncle John saying it on video. Because he's working for the government and he's covering up criminal activity right along with his homies. Okay, people? That's all they're there for. That's it. And to lock people up and to penalize them for doing the right thing. They're not interested in cleaning their own swamp. They like their swamp. Because there's something wrong with them. And they want to make sure that they have available organs when they get old because they can afford to pay for it. "41. The CIBC action was filed on January 2018. I note that timing of that filing, it was less than a month after Justice Bowden dismissed the plaintiff's action against Fraser Health Authority." Well, yeah, because I'm only one person. I can only do so much in a day. And it's not like I can go get a lawyer to help me unless I've got $50,000 as a retainer. 42. I am informed that CIBC has brought an application to strike the plaintiff's notice of civil claim, but it has not been heard as of the date of this hearing. Because they'll just do the same thing. I'll run into the same kind of judge with the same kind of lawyer doing the same kind of thing. Right? That's exactly what's going to happen. They will ignore anything and everything that I've got to show them in those 370 pages because they already got bought and paid for. The money is already in the bank. John is dead. And because they left Eleanor in the position of being manager to an immunization program that takes her all across this freaking province from hospital to clinic to this and to care homes, and she's got free reign to pick and choose who she wants to take out next, and she's going to make sure that she educates those young and up and coming nurses to know how to do it. Okay? There's your system, people. And because she's Catholic, oh, somehow it makes it okay, right? She's godly. Government doesn't want to rock that boat. They invested too much into Eleanor Gilding. God forbid if they had to retrain another crook to act like the way Eleanor acts. They don't want to make that investment when they have already got what they like. And she sure does a bang-up job now, doesn't she? I am informed that CIBC has brought an application to strike the plaintiff's notice of civil claim, but it has not been heard as of the date of this hearing. The status of that action is not important for my decision, but its existence is. 43. On the basis of the decision of Justice Bowden and Justice Savage described above, the Crown submits that at least 2 instrumental roadblocks stand in the plaintiff's path in respect to the claims relating to Mr. Duncan. 1. Justice Bowden dismissed her prior claim against Fraser Health Authority. So because it was dismissed, somehow it makes it okay to never do it again. Because they said so. There, they got you with that tunnel vision. You take the lie and you believe the lie, okay? Even though they're the ones lying. 2. The Court of Appeal dismissed the plaintiff's application for a no-fee order. However, the appeal itself is still extant. I don't know what that means, extant. I'd have to look that up. That's 2 times he's used that word. 44. The Crown submits that the allegations in this action as they pertain, John Duncan disclose no new cause of action against the Crown. The named defendants are Her Majesty, the Queen in right of British Columbia, as represented by the Ministry of Attorney General and Ministry of Public Safety and Solicitor General. The Crown submits, this is 45, the Crown submits that these parties are only named on the basis that they allegedly control the Fraser Health Authority. The Crown submits that this action is a direct attempt to sidestep or collaterally attack Justice Bowden. Okay, so I'm attacking this Justice Bowden's decision again. I like how they use that. I'm attacking him. Yeah, okay. No, he attacked my family. He hung us out to dry. That's what he did, people. Decisions and have the same issues determined by another member of this court. The Crown further submits that the plaintiff's action against CIBC represents an additional step by the plaintiff in her attempt along the same lines. They killed John, okay, people? They killed him. It's no less than murder, what they did, okay? It just took a little longer for him to die, that's all. And when he died an old, lonely man. A shell of a man, after they basically starved him emotionally of his family and locked him away like their dirty secret. And they're using dirty judges to keep that secret hidden away. 46. These are some really dirty judges. The Crown does not argue that the issue in this action are res juristica. I don't know what that means. The new action does not involve the same parties. However, the Crown argues that this action is an abuse of process. The Crown submits that this action cannot proceed because it is a collateral attack on Justice Bowden's decision regarding issues that relate to Mr. Duncan. The Crown submits that the proper avenue for the plaintiff to seek to overturn Justice Bowden's decision would be an appeal of his decision. So, go spend another $200 on photocopies and a whole bunch more money on this and a whole bunch more money on that, and go after who? Justice Bowden after they accused you of attacking him? Yeah, okay. I don't know. I might have to, people. So they want me to go after Justice Bowden. Seek to overturn Justice Bowden's decision would be an appeal of his decision, which she did. Oh, okay, but they wouldn't let me go in front of an appeal panel. As noted, that appeal is still barely alive. So what are they saying? That I can appeal? Justice Bowden's barely alive. Don't you think that's odd that he should write that down? So what? Is that appeal? He dismissed it. He told me to go take it to the cops. He wouldn't let me go in front of an appeal board, people. Unless I go pay for it. Oh no, I have to appeal Justice Bowden's decision. I don't get to appeal the decision to throw out Uncle John's stuff. I have to go appeal Justice Bowden's decision to deny me access to waiver fees so that I can appeal. Right? Isn't that what he's saying? I need to appeal Justice Bowden's decision to deny me access to waiver my fees so that I can go in front of appeal board before I can go in front of an appeal board. And I barely have any time left to do this because it's practically dead. Is still barely alive. Yeah, well, we know what you're waiting for now, don't we? We know what these guys are waiting for now, don't we? I know I said I wasn't going to say anything. I'm going to come back, though. I'm going to talk about this, okay? I'm going to get the fucking wipeout board out. I'm going to start writing down their names. I'm calling them out. I don't care. Justice Savage dismissed the no fee. Oh. Well, I was trying to appeal Justice Bowden's, but they wouldn't let me do it. Justice Savage dismissed the no fee application because the appeal had no chance of success. How is he to determine that, people? How can these individuals that randomly come from nowhere assume whatever it is that they assume? Like, I don't get it. Like, there's something missing there. Because the appeal had no chance of success. He also set out the reasoning behind his decision. However, he did not dismiss the appeal. Exactly, he didn't. He just sent me away. He said, go take it to the cops. Left me fucking hanging there. And then Shamay was murdered. And I've been gang stalked even harder ever since. "47. I accept the Crown's submission on this point. The portion of the notice of civil claim dealing with claims relating to Mr. Duncan and the power of attorney, there's more than one, but they keep ignoring the enduring power of attorney, which is there for a reason, is an attempt to launch a collateral attack on Justice Bowden." He said that like, what, 3-4 times already, people? Decision. Such an attempt is clearly an abuse of the court process. 48. Beyond the Crown's first argument, I further find that this portion of the claim is bound to fail. It is bound to fail for the reasons set out by Justice Savage above. This judge wasn't interested in going over the paperwork, people. He wasn't interested in talking about legislation. He wasn't interested in talking about mandates and rules and all that other stuff. He wasn't interested in talking about the Power of Attorney Act and the difference between enduring power of attorney and power of attorney. He wasn't interested in talking about illegal acts like mail fraud and bank fraud. He wasn't interested in talking about illegal detainment of a patient in a healthcare system where somebody was roaming the halls, stalking and planning and scheming to steal his money and remove him from his life. He wasn't interested in talking about any of that stuff, people, okay? But yet he made a decision on information that was bias, prejudice, and probably a whole bunch of other words in there too. Okay, like this makes me so sick. Like, these guys are evil. They are so evil. This is evil shit, people. This is so evil shit. I'm not going to wish evil upon these things, okay? These individuals, whatever the hell they are, because I really don't think that they're all human. I don't. I just don't. There's something seriously wrong with them, okay? There is no justice in our court systems, all right? The only people who are getting justice around here are the ones that are committing the crimes. They're the only ones, okay? The Eleanors, the Punjabis that like to illegally harvest organs as they're coming in with the overdose fentanyl because of, you know, the government is convinced the public that those people deserved to get what they got because, you know, there is no such thing as murder by fentanyl, right? You know, and that every worker that is signed on with the government is somehow freaking a Puritan. Like I said, they're godly. They're godly. Well, if they're so fucking godly, then, you know, like, then there must be something different about them. You can only be godly if there's something different about you. Something that's not normal, like a normal human being, okay? Just put it in that way. If you can't look outside the box, right? But yet the individuals are so godly, so right on every point that they have, then they must be altered. There has to be something inside of their DNA that isn't normal to make them so godly, so right all the time, so correct, so ethical, so pure, because this is what this shit sounds like, when in fact this guy is just running around trying to cover up the tracks of the government with their, I don't know what those things are that work for them, okay? I just don't know. I feel sorry for the real humans in there that have to freaking deal with these things, because just like they came after Uncle John, they're going to come after the ones that are like Uncle John in terms of 100% human DNA, okay? These ones that are been spliced and diced or injected with something or had brainwash or who knows what influences them, people. I don't know what influences them. All I know is that this is sick. This is so sick. So sick. So sick. Accusing me of attacking a judge. Yeah, okay. Purposely going out of their way to ignore enduring power of attorney, purposely going out of their way to ignore Uncle John's own words in living video, right, in color, purposely going out of their way to okay, let's just stay focused. I knew this was going to happen, people. I'm not surprised. Okay? Because this is their game. This is what they do. And it's going to get worse. Lots of people know it's going to get worse. But they got their own issues that they're fighting up against. So it's not like they can help me. Right? This is something I have to do. In terms of standing my ground. I don't care what they say about me. I don't care. I don't care what they do to me. I'm not dropping the ball. I don't care if everybody abandons me. I'm not dropping the ball. This is pure evil. These guys represent evil. Okay. That's why they got Shamay hanging upside down in front of their court registry counter. Literally strung upside down with the rest of her family. I further note, number 49, I further note that this action was commenced in 2020 on top of, I guess I should read a little further up. We're almost done, I think. Included in those reasons is the fact that Mr. Duncan died in 2017. Any action would have to be brought by the executor or administrator of his estate. Well, that would have been me with the enduring power of attorney and power of attorney, but that was illegally taken away. But you see, that's the thing. It was never taken away, people. It was just hidden away. The judge is just burying it deeper. That's all. And that's why I'm starting to think that maybe I should just photocopy these things, put them onto PDF, and start posting them online. I might. Any action would have to be brought by the executor or administrator of his estate. Miss Chorney is neither. But I've only been fighting how many years? Because Uncle John deserves justice. Because in essence, he was basically murdered by his sister and her friends that work in the healthcare system and paid off a bribe in the bank to launder money because she's so ethical. She has no standing to bring any action for any wrong suffered by Mr. Duncan. Do you see how easy it is for them to come in and just take what they want when they want? Just like when Amari had his seizure, it just took one asshole to make a phone call and put me into check with everybody whispering around, which is now going to follow me from place to place because of MCFD, right? Even though everybody was waiting for the seizure. Like I said, it's not like they weren't waiting for it. They were disappointed that it didn't come. And then when it did come, they used it against me, people, as they were accusing Shamay of creating the problem, as they ignore the facts in terms of they don't even want to look at the documents. They just want to assume and accuse you of attacking judges. This is sick. This is sickness. This is sick. It's just sick. It's just twisting words around. She has no standing to bring any action. Yes, I do. He's ignoring the enduring power of attorney. Okay? He's ignoring John's wishes for me to go get a lawyer. Oh, I guess he didn't see that video. Right? He didn't have time. Because it wasn't a trial. So therefore, it's insignificant. He's ignoring murder because the government told him to. Okay, stay quiet. None of the named defendants in this action owed a duty of care to Miss Chorney in respect of the issues relating to Mr. Duncan. So, when you get old, be prepared to be pillaged at any given moment, because it could happen to you and nobody's gonna give a shit. Nope. I further note that this action was commenced in 2020 on top of all other issues. The limitation period for any action would have expired. That's not true. There is no statute of limitation on murder and what results from that murder. And there will never be, in my mind, a statute of limitation for cover-up, gang stalking that's perpetual as they continue to cover up what it is that they initially did because they want to continue doing it to other people. Okay? That's just the way it is. Right? If they feed you a lie long enough, they expect you to believe the lie. But just because they expect you to believe the lie doesn't mean you have to, unless, of course, you're gullible and you're weak and you're afraid to die on principle. Okay? More than 2 years elapsed between Mr. Duncan's death and the commencement of the action. It is clear that the plaintiff could not argue that the running of the limitation period was told or delayed, because she commenced 2 prior actions alleging the same wrong by other entities. Yeah, exactly, entities. We're dealing with entities here. We're not dealing with human beings. We're dealing with entities here, okay? Just keep that in mind. All right? Hence, I find that this action, as it relates to allegations regarding Mr. Duncan, must be dismissed for at least 3 reasons. It is a collateral attack on the decision of Justice Bowden and, as such, an abuse of process. It is bound to fail because the plaintiff lacks standing to bring the action. Any limitation period has expired. There is no limitation on murder. As far as I'm concerned, they murdered John. It just took a little longer to do it. It took 3 days to murder Shamay. It took 3 years to murder John. Murder is murder. And we know that they had Sierra in a snuff movie because there's just way too much money to be made on the black market through the dark web. Something these dirty judges like to look at when they're not busy doing their job. Does that mean every judge likes to look at that? No, but a lot of them do.
done?
No. On that basis, the claim relating to Mr. Duncan must be dismissed. Who says? You? A man with no power? Okay. Clearly. Other claims. Before addressing the plaintiff's other claims, I note that in submission, you see, that's why he pretended to be so friendly, because he wanted to kill all the flies and hang us all up, strung up by our ankles upside down in one swoop. Okay, that was the only reason he showed any interest, was to gather us all up as a whole family and string us up upside down at one time and keep us there. Okay? Okay? The guy was a fake. He's a fake. Before addressing the plaintiff's other claims, I noticed that in submissions, the plaintiff, through her litigation friend, acknowledged, turn it down! Acknowledged that some of the allegations discussed below and in balance of the notice of civil claim were driven by Miss Chorney's suspicions and emotions. I understand from that submission that the main issues that the plaintiff wishes to pursue relate to Mr. Duncan. Hence, the issues discussed below, in my opinion, are less tenable than the allegations relating to Mr. Duncan. However, the following allegations are not subject to any existing or past civil proceedings. I don't know how many pages we got left. Maybe I should come back. The Crown's submission in relation to the remaining elements of the notice of civil claim can be divided into four main categories. 1. None of the harms alleged in the notice of civil claim was done to the plaintiff. Yeah, okay, people. Okay. Yeah, okay. As a result, she is not a proper plaintiff. You murder my daughters, you injure my grandchildren, you kidnap my stepdad, torture him, isolate him, and then basically kill him through loneliness and isolation. You injure my grandson, you use him as a test subject to take public tax dollars to boost up your research studies, and whatever else you do. You illegally apprehend small children that are in functioning, loving homes as you create junkies by illegally evicting innocent, vulnerable young women who turn their life around and were doing really, really good, and then accuse me of not being involved emotionally, physically, or anything in relation to all of what is around me. Knowing that nobody is capable of fighting back except for perhaps me. And then you accuse me of attacking judges for being impotent, selfish, and crooks that clearly are bought off to one degree or another. Or maybe they just don't want to lose their jobs, being that the government told them to dismiss it. That's bullshit. That's total fucking bullshit. What? You didn't kill me? You didn't hit me on the head? You didn't give me brain damage? You didn't snatch me up and put me over there and lock me up and mistreat me? What? You didn't, just because you didn't do it to me personally, you did it to those around me, people. That's what these things do. And now they throw it up in your face saying, well, it didn't happen to you personally, so therefore the dead is dead. Let them fucking be dead. They can never speak for themselves. It's all underwater to the bridge. Just forget about it and move on. Nobody cares. It just makes me sick. I'm not going to stop fighting people. I'm not. I'm not going to stop fighting. This judge is a slime ball. He's a fucking slime ball, okay? I don't care if he's watching my videos or not. Fuck you. Fuck you. Fuck you and fuck anything that you stand for. You're a fucking slime ball. Don't you dare say it never affected me when all I could see was my kids being damaged by your kind. With the same fucking mentality. You're sick. You things are sick. You need to be exposed. Brought to the light. And maybe when the sun hits you, you'll fucking wither up and die. Get off the freaking planet. Seriously. You've been hiding out in the dark for too long. Been getting away with too much shit. None of the claims alleged in the notice of civil claim was done to the plaintiff. So when my turn comes and I'm in the next snuff movie as they're torturing the life out of me with my kids standing outside the door saying, well, can we identify mom's body? And the dirty fucking cops are going to say no, no, no. And they're torturing me like they were torturing Sierra and doing their little recordings and all this other stuff. Well, you know what? I won't be able to fight back, people, because by the time they're done with me, I'll be fucking dead. So they win either or. It doesn't matter. Don't you see how it works? As if my kids could do what I've done all these years, knowing how far it got me. You think they're going to step up and fight for me? Hell no, because they're next in line. Okay? They're next in line. Right? What, only a lawyer that's associated with the Bar Association can fight for my family, but not the mother? Not the adult in the house? They're not allowed to fight? But they're expected to fight for themselves when they're dead? How is Uncle John supposed to fight for himself? He's dead. How is Shamay supposed to fight for herself? She's dead. How is Sierra supposed to fight? Huh? She's dead. You tell me how Amari's supposed to fight for himself? He can't even freaking talk and never will. But But because I'm not the one that got injured at the time of the birth, I have no right to fight for my grandson. I'm not the one that was medically kidnapped and drugged up and put in the bowels of a ferry, shipped over to some freaking hospital that just was doing God knows what with Uncle John so that his money, because it didn't happen to me, right? I'm not allowed to fight. I'm not the one that got lured to the death. So until I get lured to death, like Sierra, I get lured to death, until that happens to me, after I'm dead, then I can come back and I can fight people. Then I can come back and fight. Are you listening to this nonsense? This nonsense. This is negligence. This is gross fucking negligence, okay? This is breach of trust. 2, none of the harm alleged in the notice of civil claim was perpetrated by the defendant. The defendant is responsible for their employees. The defendant is responsible for the public union sector as a whole to make sure that they're not corrupt and evil and disgusting. Disgusting. As a result, the province is not a proper defendant. So then why do they write the legislation? Just because they can? After they write it, they don't give a shit what happens to it, right? Right? You know, it's just a free-for-all, right? People can do what they want with it, obviously. 3, this court does not have the power or jurisdiction to order an investigation. Of course not, because he was ordered by the government to dismiss it. So what was the point? There was none, because it was already cat in the bag for the government, because the government is corrupt. They only expect you to come back and fight when you're dead. When you're dead, then you go to court and you fight for yourself and your family. Because your family ain't going to be able to do it. Only you can do it. But you're dead. So make sure you find a way to get back, like Shamay. Make sure you find a way to get back. Even if it means they got you hung upside down, like a hog. Other allegations relate to long past events that are clearly out of time. No. No. There is no out of time for Uncle John. He didn't deserve what he got. Or anyone else for that matter in this family. (54) In addition, despite the preliminary nature of this application, the defendant submits that I should not accept the allegations in the notice of civil claim as being either true or capable of being proven. That judge got 370 pages of legitimate documents that proved I had enduring power of attorney since 1990. I had it for 25 years with no disruptions, no interruptions until John was medically kidnapped and his sister wanted to steal his money. And she used her position of authority within the healthcare system and within the province to do it, as she bribed the bank to jump on the bandwagon, because at the end of the day, Uncle John is not and will not be her last victim. In that regard, I return to the description of the various claims that I set out above. Sierra Chorney, she can't represent herself because she's dead. How is she supposed to come back and stand in front of a crooked judge and say, help me to get justice? She can't. The plaintiff alleges misconduct by employees of Fraser Health Authority in respect of the death of Sierra Chorney. Oh no, it goes deeper than that, people. The plaintiff's daughter, Sierra Chorney, the plaintiff's daughter. The plaintiff alleges that Sierra's organs were illegally harvested and sold on the black market. Yeah, that was the only reason they did a forensic autopsy on an active addict that was turned into a junkie because of a social worker 8 years prior. It's one thing being an addict, it's another thing being a junkie. Sierra became a junkie because of a social worker. And she was pimped out on the streets for 8 years until she was lured to her death. And then all of a sudden, dirty cops wanted to do their forensic autopsy because they needed a reason to cut her open in order to get the organs, because they couldn't do a repeat like they did with Shamay and take Sierra's body and pretend that she was alive and hook her up to machines at the hospital and embalm her after they took out their organs, and then tried to fool the family because they already did that once with Shamay. Because it's a game with them. Because they're sick. They're like pedophiles. They're sick. They're sick. This is a sickness. I'm bringing it to the light, people. I'm showing you the sickness within our system. The proper plaintiff, the proper plaintiff would be the administrator of the Sierra's estate. Well, she had nothing. Welfare was ripping her off and wasn't even giving her checks half the time. She was homeless, as if she had anything in an estate. I am her mother, but I guess I'm going to have to go to court and get appointed as whatever it is that they want me to be, so that the next time I come back with my videos, did you get the stuff? Did you? Huh? Let me see. I want to see the stuff. Oh, aren't you coming back? Are you coming back? Oh, right. You have to come back. You got to get the body. I forgot. Sorry. Oh, wait. No. We're going to do an investigation. Right? So we got to take her for an autopsy. Forensic autopsy. To find out what killed her. Even though we've only been drugging her up and keep her strung out in the streets for 8 years with fucking fentanyl. As we abused her, trick after trick after trick after trick after trick after trick. Okay. And a lot of those fucking dirty assholes were judges. Don't tell me I don't know how the fucking game works, people. Dirty judges, dirty cops. Dirty pigs. And this judge wants Sierra to come back from the dead and defend herself. Yeah, okay. The plaintiff alleges, okay, we read that. 57. The problem with these allegations are following. A. The proper plaintiff would be the administrator of Sierra's estate. I'm going to have to do that for Sierra, and I'm going to have to do that for Shamay. I already decided that before I read this shit. I've been thinking about it for the last couple of days. But of course, we'll run into roadblocks with that, won't we? Right, people? We know. They'll just find another way to hurt me, or hurt somebody else around me, or fuck over my eyes, or cut me off of welfare or threaten to kick me out, or who knows. Because they're not going to want me to get any more information than I already have. B. The plaintiff is not the administrator of the Sierra's estate. What? The government? Oh, I'm sorry, John Hart. The one who identified Sierra's body behind that closed door with those dirty cops who decided to investigate John Hart so that they had an excuse to take Sierra in for a forensic autopsy. If it wasn't for John Hart, there would be no forensic autopsy, and that would have been it. But they still would have taken out her organs anyway, right? But you see, if they didn't do the forensic autopsy, I could have donated them. But they don't want you to donate them unless you absolutely have to these days, because there's too much money to be made. What is in the dark will come out in light, people. C. If there was any basis for the claim, the proper claim might possibly be made against the Fraser Health Authority. There is no claim against the current defendants. So, if your children are having their body parts pillaged and you find out about it, don't take it to the government. The government doesn't give a shit. Take it to the authority, the health authority from where the hospital is located, and sue them. And then when they throw it out of court, right, because they will, just accept it. Believe the lie and save yourself a lot of stress, or grow some balls, stand up, and fight for justice. Otherwise, it's just going to continue happening, people. Right? We're on a depopulation agenda right now to bring in transhumanism so that sick things can live forever. I don't know why you want to be subject to that situation and not fight back. That's like, you know, when people like genocide, you know, they just, go ahead, kill me. Go ahead, just starve me. Go ahead, just work me to death. I'll never fight back. No, it's not in my character to stand up for nothing. Just go ahead and mow me over with a freaking bulldozer and flatten me out like a pancake. No problem. If there was any basis for the claim, the proper claim might possibly be made against Fraser Health Authority. That's what I said. They want me to take it back to Fraser Health Authority, even though Fraser Health Authority is a corrupt corporation, crown corporation that gets paid by the government. That's expected to follow the government rules, but doesn't. I don't know how that works, right? If they're not following the government's rules, you would think that the government would go in there and clean up the corporation, but they don't want to. 58. I accept that defense submission on these points. The action as it relates to issues surrounding the death of Sierra Chorney is bound to fail, but he had no evidence to base anything on that. He never received any evidence. He never received, all he got was insinuendos from the government and a blip here and a blurb there from us, because we didn't have that long talk. I had an hour, people. I had 1 hour, okay? 1 hour after lunch to talk. And that guy turned around and took over half of that hour just trying to, you know, put everybody into a silo. That's what he said. I'm going to silo everybody. Well, you sure freaking fucking siloed everybody, didn't you? You strung them upside down and you hung them out to dry like freaking gutted pigs. That's what he did, people. That's what he did. That's what he did. That's what he did. That's what he did, people. Okay, I can't finish this right now.